Senate Judiciary Committee will come to order. The Senator from Nebraska, Senator Sasse.
Thank you, Chairman. Judge, welcome back. By my quick eyeballing count of this, you are 51% done as of this moment, which feels more like curse than blessing, but I meant it as a good thing.
Thank you.
I think I'm number 12 of 22, so you're just past halfway down on the downhill. Thank you as well for spending time with me in my office, and thank you for answering the questions of the committee today and tomorrow. What you've said in public matches what you've said in private, and that's obviously a testament to your character. That also can be helpful to rebuilding public trust. So thank you for the ways you've engaged thus far. Judge, you are likely to go on to serve a lifetime appointment on the Supreme Court, which means that this is very likely the last job interview you ever have.
And the most public, Senator.
Yeah, these processes are a lot like a proctology exam. That means that it's an opportunity for you to explain to the American people how you view a Supreme Court justice's job and the limits and bounds on that job. So I want to go back to a topic that you and I have discussed a few times, which is how you approach cases. You've told this committee and you've told me in private that you don't have a judicial philosophy yet, but that you think of yourself as having more of a judicial methodology. I'd like to understand that a little bit more. And I think it would be helpful for the American people to understand that argument and that distinction a bit more as well. Earlier today, you said that you, quote, do not believe there is a living Constitution. And you also said that you're constrained to interpret the text, and that I think you said sometimes that's enough to resolve the issue. So I think I've heard you pay partial tribute to the judicial philosophy of originalism, but you've not adopted it or embraced it as a philosophy or label that applies to you. So maybe one of the places we could tease that out a little bit more is trying to dig into whose jurisprudence you most admire. We've heard many nominees before, like Senator Grassley, former chairman of this committee. I'm not an attorney, so the farming and ranching people where I come from know that John Kennedy is super smart Rhodes lawyer who kind of pretends to be a aw shucks kind of guy as he picks your pocket. Grassley and
I get equal time, Mr. Chairman?
he always gets unequal time. He always gets bonus time, but I think it might be helpful for us to understand who you most identify with, and past nominees before this committee have talked about the mold of particular justices they thought they followed in. And so if you had to tell the American people who you're closest to, who is that justice, or who are those justices?
Well, thank you for the question, Senator. And I must admit that I don't really have a justice that I've molded myself after, or that I would. What I have is a record. I have 570 plus cases in which I have employed the methodology that I described, and that shows people how I analyze cases. I, in every case, am proceeding neutrally, from a neutral posture. In every case, I describe thoroughly all of the arguments that are made in the case to me as a judge, because I want, in my lengthy opinions, for people to understand the inputs. This, I say, is what I'm considering, because I lay out in very, detailed way everything that people have argued in all of the cases. And then when I'm doing my interpretation, I am focused on the text of any statute or constitutional provision. I am looking as appropriate to the intentions of the people who wrote the words, because I view statutory interpretation, constitutional interpretation, those exercises consistent with my limited authority. I am conscious of not interpreting those texts consistent with what I believe the policy should be, or what I think the outcome should be. I am trying in every case that involves that kind of interpretation to assess what it is that the parties who wrote the text intended. And as a result, because my methodology involves these various pieces, and because of the way in which I do things, I'm reluctant to establish or to adopt a particular label, because the idea of how you interpret is just one part of the entirety of a judge's responsibility. As I mentioned, I'm looking at the facts in a case, and my experience as a trial judge helps me to assess the facts from all of the different perspectives of the parties, because I'm able to do that, I think, having heard from parties in all sorts of cases directly as they present their arguments. That's a part of the judging responsibility that isn't really captured by something like originalism or living Constitution. And I believe that the Constitution is fixed in its meaning. I believe that it's appropriate to look at the original intent, original public meaning of the words when one is trying to assess, because again, that's a limitation on my authority to import my own policy views. But there are times when the meaning, unreasonable searches and seizures, due process, looking at those words are not enough to tell you what they actually mean. You look at them in the context of history, you look at the structure of the Constitution, you look at the circumstances that you're dealing with in comparison to what those words meant at the time that they were adopted. And you look at precedents that are related to this topic. All of those tools judges use, and I have used, is if you look at my cases.
But when you say that you look at the intent of the authors of a statute, sometimes courts have to say the people who wrote this statute, whether they meant to or not, have done something that we, the judiciary, decides, speaking in the voice of you, is unconstitutional. And deciding that something is unconstitutional requires an interpretive framework for how you get there, right? And so you and I talked in my office about the differences between Justices Kagan, Breyer, and Sotomayor's judicial philosophies. And you told me that you needed time to study that issue further. So assuming that you've had a chance to think about that a bit more, I guess I'd ask you again, what are the differences among the three of their judicial philosophies?
With respect, Senator, I have not actually had time with all of my meetings with senators and the work that I've done to appear before you today. I would say that there are differences, as you see from the various opinions that they have issued. I'm not sure which one I would necessarily follow, because it depends on the case. I think their differences indicate that they are looking at different provisions. They are using the various tools that judges use and that I have used in my cases. The idea of striking down a statute as unconstitutional is daunting and should be daunting, I think, for any judge or justice, and would have to be looked at very carefully because of the limited nature of the judicial role and the fact that the policies have been adopted by the branch of government that has that authority under the Constitution.
So I guess I'm surprised after 9 years on the bench that, I mean, you're super smart. Nobody disputes that. And having worked for Justice Breyer and knowing of some of the fights, some of the philosophical arguments he and Justice Kagan had, it just seems surprising that you wouldn't be able to at least not speculate, but reflect a little bit on the nature of those disagreements. Because to say it depends on the particular case, that's fine, but they have different philosophical and hermeneutic approaches to the text. So maybe another way to get at it. I think Justice Breyer, again, for whom you clerked, and Justice Scalia used to travel together and have lively debate circuit conversations. Can you tell the American people a little bit about what Breyer-Scalia roadshow looked like? What were they arguing about?
Well, my understanding is they were arguing, or at least presenting, two different viewpoints as to how the Constitution should be interpreted. And I would say, just as an aside before talking about their positions, that while I have been on the bench for 9+ years, the issue of constitutional interpretation in that sense doesn't come up very often. It comes up to the Supreme Court for sure, but it doesn't come up very often in the lower courts. What Justice Scalia and Justice Breyer, I believe, were debating was Justice Scalia's notion of originalism, meaning that the words of the Constitution should be interpreted as they were written by the founders in the founding era, and that they should not be considered to essentially to establish principles that modern justices could now apply based on their own view of the needs of society. And that Justice Breyer's position was more toward that latter view, that the idea of the Constitution needing to be interpreted in a way that is consistent with modern sensibilities about the principles that the document reflects. And I would just say that it appears now that the Supreme Court has taken Justice Scalia's view that the prevailing interpretive frame for interpreting the Constitution is now very clearly looking back through history. So we see that even in the Heller case, where the justices, even the justices in dissent, were all analyzing the issues in the Second Amendment through a historical lens, what was meant at the time of the founding. So that is now the way in which constitutional interpretation is done.
But do you identify with that position?
I identify with the position insofar as that's how the text is interpreted of the Constitution. That I am a strong believer, as I said, in precedent, in stare decisis, in predictability, in the rule of law, and the way that the law now interprets the Constitution is through this historical frame.